What's up, y'all? Welcome to the docket presented by Defense Diaries. I'm your host, Bob Mata, and I am here solo tonight. Allie she's got a deadline of tomorrow for that nightmare post-conviction relief act petition she's been working on for now 4 months. Tomorrow it ends, so I was in no way going to beg her to come on with me. So I'll be rolling solo tonight. Welcome to our continuing coverage of the people of the state of Indiana versus Richard Allen. If you're not aware, Richard Allen is currently going to be going to trial in a little less than 3 weeks, as he is alleged to have committed the homicides of Liberty German and Abigail Williams back on February 13th/14th of 2017. That case went cold for 5 years. In October of 2022, they made an arrest, and it was Richard Allen. So over the past year and change, we have been barreling towards trial, and it is coming. It will be here in the blink of an eye. And I try to tell people that it seems like, for me, like I've been talking about this for 60 days, how quickly 60 days would go. And now here we are 3 weeks away. In 3 weeks will feel like, one day. It's like the thing, Steve Martin was talking about in his relationship. The first day felt like 4 days. The second day felt like a week. The third day felt like a day. But the fourth day, something like that. So, but time just flies by. And as I anticipate, we had filings come in today. We had 2 by the state. We had 1 by the defense. I fully expect a barrage of filings to come in over the next 3 weeks. I fully anticipate that we will see a ton of motions in limine. Motions in limine come typically closer to trial. And typically those are dealt with on one date. The judge will set a hearing date, usually on the last pretrial date before trial, and they will go through all the motions in limine. Some of those are very elementary things like exclusionary motions to keep witnesses out that are going to be testifying in the case, that they can't sit in during the trial and listen to everybody else's testimony. Some are more complicated, and I fully expect there to be some more complicated type motions filed and some issues to arise, because it's been a complicated case. And that's the facts. So in light of the fact that I already have streamed all day today the Chad Daybell trial with my buddy, the Shaming JJ, I am going to not waste a bunch of time yapping. I'm going to jump right into the reading and the discussing of these particular motions. The first one I'm going to pull up is going to be the motion for leave of court to subpoena third-party records, which was filed by the prosecutor's office. And it's an interesting filing, not in the filing itself. Leave of court to subpoena records is very common. What Nick McClelland in the prosecutor's office is asking for in this particular circumstance is very uncommon. I can honestly not remember a time where I have seen a prosecutor's office go after another PD department that's obviously outside of Carroll County. But I'll kind of get into why this is so surprising to me after we read through it. And just so you know, I am not going to be reading the actual subpoena ducis tecum. Those are going to be standard. Those are boilerplate. They're not specifically written. There may be some specific language in it, but for the most part, it's going to be, maybe I'll read through the documents and records to be produced. Anything that's specific to this particular document, I'll read, but the boilerplate stuff I'm not going to read. All right, so let's jump right in. All right, so comes now the state of Indiana by Nicholas McClelland, prosecuting attorney for the 74th Judicial Circuit, and moves this court for an order for Rushville Police Department, uh, Chief Craig Tucker, to produce to the Carroll County Prosecutor's Office, Nick McClelland, any and all employee records for Todd Click associated with his employment at Rushville Police Department. Now, if we happen to have some individuals in here who are not aware of who Todd Click is, Todd Click is one of the three law enforcement officers that continued down a different path than the Unified Command had wanted to take. It was Todd Click, it was Ferenczi, and Murphy are the three guys that continued down this path that was very, very different than what the Unified Command was wanting to do any further. They had looked into Brad Holder and Messer and Fields, and they had come to the conclusion that they were not interested, and that they felt that it was a dead end. So they moved on, and these three officers continued for years. From 2018 till Ferenczi was killed in 2021, to look into this angle. And Click is still very much of the belief that this angle is the correct angle, and that these gentlemen are more likely involved than Richard Allen. That's Click's feeling on the matter, and he came in on the motion to dismiss that was filed by the defense and testified as such. That was where, we kind of got to hear directly from the horse's mouth what his particular feelings were with respect to the arrest of Richard Allen, and his investigation, and Ferenczi and Murphy's investigation into these other individuals. And he was concerned. He was concerned at the time that the arrest was made, and he made that known to Nick McClelland. He was hoping that they would assuage his fears by having him come in and say, hey, look, this is what we got on this guy. It's solid. That didn't happen. So, that leaves us basically where we're at now, where we know that Click is going to be a material witness for the defense. He is going to come in and he's going to testify to what he testified to in that motion to dismiss. And I'm assuming that it will be more, provided that Gull lets him go there, which is to be determined. She obviously has the ability to be able to rein the defense in as far as third-party culpability. I believe that she'll give them some leeway. How much is the question? If she starts to feel like the defense isn't making any headway with it, or if it seems to be nothing more than a fishing expedition, she will cut it short. So his testimony is very, very important, obviously, which when you think of that in light of why this was filed, it'll kind of make sense. So let's keep working through it. So while working the Delphi investigation, Carroll County Sheriff's Department Detective Tony Liggett developed information that Richard Allen was involved in the murders of Victim 1 and Victim 2. During the investigation, then Rushville Assistant Police Chief Todd Click participated in following up on leads and interviewing parties associated with those leads. The defense had listed Todd Click, or has listed Todd Click, as a witness they intend to call during their case in chief to express his belief that other people were involved with this crime. The state believes that Todd Click has employee records that show a Brady Giglio violation that could call into question his credibility as a witness. The violations could also call into question the veracity of his testimony. That statement right there, blew my mind. Typically when you're talking about a prosecutor's office, and granted, Rushville, 100 miles away from Delphi, 100 miles away from Carroll County, not in the same area. These are not cops that McClelland works with. These are not cops that McClelland is going to have testify in cases in the future. So I think in that sense, McClelland felt that he was free to essentially attack this department Because make no bones about it, uh, if it turns out that he is correct, if it turns out that Todd Click has Brady or Giglio violations um, in his records, and that would mean that his boss was aware of it. That would mean that the prosecutor in whatever county Rushville is in was aware of it. And that means that almost every case that Click had his hands on or had his fingers on, every case that that prosecutor or prosecutors may have tried comes into question. It is such a like a devastating thing for a prosecutor to do to another police department uh, merely by way of trying to destroy the credibility of Todd Click leading into trial, which is what I think the move is. Do I think that they're going to find Brady Giglio violations? I have no idea. I don't know. But what I do know is that the effect of this motion, once it gets started to be reported by the media, and it will be, that it is going to do exactly what it needs McClelland to have it do, which is to destroy the credibility of Todd Click leading into the trial. It's a move. It just is. Now, if it turns out to be true, then it was the correct move. I mean, if it turns out that Todd Click is not a credible person, is not a credible cop, if he's a cop that cheats, uh, that should be exposed. There's no question about it. If it turns out that it's not true, um, the question then becomes what happens with Nick McClelland in terms of filing what would turn out to be a frivolous motion that really tries to go to the heart of the defense's theory. If Todd Click becomes a joke in the eyes of the public, and the public, make no bones about it, again, is the potential jury pool. I don't know that it matters what happens after this comes out. It's like one of those you cannot unring a bell situations. You could pull the skunk out of the jury box, but you can't get rid of the smell. It's out there. Like the general public just does not dig in like the 550 people in this particular live are digging in. They see a news story on the news, they hear about it, and that's it. And that's what the people in Allen County, they're not digging into this case like the people in the true crime community are. They just aren't. So if this gets aired up there and somebody sees a news report on this, and they're talking about the defense's star witness, that he's got potential credibility issues, that he was withholding exculpatory evidence in cases, it's going to stick with people. So I can't help but feel that it's a move, having no idea whether or not what he's alleging is true. I can tell you without knowing the answer to that, either way, that it's a move. And depending on what the actual answer to this is going to be a very interesting result as to what we do with Nick McClelland. Because, he likes to call everybody liars on the defense, which is unusual. I mean, I argue with attorneys my entire career on the other side of the aisle all the time, and we disagree about things adamantly. But the one thing that was never happening is that we weren't calling each other liars, with the exception of one case. But for the most part, you just like we're all officers of the court. Every attorney, whether you're a prosecutor or defense, we all take the same oath, and we are all held to the same standards, and we all have the same duties. And it's not taken lightly within the profession for lawyers to call each other lawyers or liars. So, and McClelland's been doing that like frequently. And if this turns out that this is based on nothing, or based, I am anxious to see the responsive pleading to this by the defense, because one thing that I know is that if I'm Brad Rosie or Andrew Baldwin, I'm calling Click immediately and I'm saying, yo, like, is there any truth to any of this? Is this like something that we need to worry about? And Click is telling them, well, maybe or absolutely not. So we'll see how it plays out. But man, it's a move. It's a big move by McClelland and a dangerous gambit in my estimation. So, based on this information, the state has filed a motion for leave to obtain these records. The state is requesting the employee records, the employee records typo, the employee mental health records for Todd Click for his employment at Rushville Police Department, specified in the attached subpoena Stussus Tecum, and/or request for production of documents and records to a non-party. So, first, McClelland says, all right, well, we think that he's been hiding evidence. He's been playing hide the ball on his cases. He's been holding back exculpatory evidence. And now McClelland's implying that Todd Click could have mental health issues. It's a big move. It's a big move by McClelland, I'll tell you. This request is made for the purpose of preparing for trial in this matter. The state believes that Todd Click will be a witness by the defense to support their theory of the case. The state believes the employment records of Todd Click are relevant and would assist the state in preparing for trial. The state of Indiana has contacted the defense in the case, and the defense does not object to the subpoena and would waive the 15-day notice. I can imagine that conversation. I would have loved to have been a fly on the wall for that conversation. It must have been interesting. Wherefore, the state of Indiana, by Nicholas McClelland, prosecuting attorney for the 74th Judicial Circuit, respectfully prays that this court review the attached subpoena and then order production of said records, as such relief is just and proper in the premises. So, like I said, I'm not going to read through this. The beginning is the instructions. Tells you when you have to turn it in. So this is what he's asking for in one of the subpoenas, Deuces Tecum. Deuces Tecum just means records, okay? Papers and records. Okay, so he's asking for any employment records for former Assistant Chief Todd Click for his employment with the Rushville Police Department, and any other documents, records, notes, videos, and or writings that make up Todd Click's employment file while being employed by the Rushville Police Department. Now, I guess my question becomes, does Nick McClelland believe that when he gets Todd Click's employment file, that there's going to be contained within that a separate file that says Brady violations? I mean, I don't know. I have heard nothing about Todd Click losing his job because it was discovered that he was committing Brady violations. It's very unusual. It's a very, very unusual rule. I've never seen anything like it, but not with a prosecutor. I've obviously seen defense attorneys go after it all the time. To see the state, it's a very unusual rule, or a very unusual circumstance, I should say. All right. So pursuant to Rule 2 of the Indiana Rules of Criminal Procedure, you're hereby directed to produce to counsel for the Carroll County Prosecutor's Office, Nick McClelland, all documents requested in the accompanying request for production of documents to a non-party, and an executed affidavit of the custodian of records, which would essentially say, I've given you everything that you've asked for. And this is the affidavit. So that's that doc. Kind of blew my mind. I thought it was kind of a bombshell. Not so much in what it was on its face, but the fact that I've just never seen a prosecutor do that ever. Very unusual. Very unusual. I'm just not aware of it. And I mean, it's I'm curious if the prosecutors down in Rushville, and if anybody knows what county that is, I don't know. But if you want to throw it in the chat, I'm curious if, and not only current, but former prosecutors, like the prosecutors that may have been handling cases back when Click was still down there, you know, like called up and said, what the fuck, man? Like, are you serious? Like, without you, is this like for real? I don't know. It's wild. Like I said, I'll be anxious to read what the defense's response is. All right, so Nick also filed another motion today, and it is his response or the state's objection to the defendant's motion to suppress, which was filed April 11th. And then he's got his preamble here. We'll just jump right into it. Paragraph 1, excuse me. The state has provided the defense with statements of Richard Allen. Those statements include phone calls made by Richard Allen to his wife and his mother, and statements that he made to the Indiana Department of Correction staff and inmates. The statements made to the Indiana Department of Correction staff and inmates, referred to as suicide companions, consist of statements on, quote, door sheets. These door sheets are forms provided by the Indiana Department of Corrections for monitoring the behaviors and statements of Richard Allen at a frequency determined necessary by mental health personnel. That the state, not in paragraph 2, that the state has identified and provided the names of all suicide companions, which the state intends to call as witnesses for confessions and relevant statements against his own interest, which includes 16 correctional officers and 8 inmate companions, Warden Gallipo, mental health personnel, and the Indiana State Police officers. Paragraph 3, and like I was seeing today, there was like in my chat on our in our Facebook group, the Insiders group, like it looked like people were assuming that because of the number of witnesses that have been named, specifically 16 and 8, that people were under the impression that that meant that there were 25 confessions. I don't read it that way. Does that mean that I'm correct? No, not necessarily. But I don't read that as that means that there's 24, not including the phone calls to his wife and his mother, that there's 24 plus confessions. I don't read it that way. I think that multiple correction officers would probably be privy to certain things that were said. And I don't think that equals a number. But, you know, there's going to be people out there that say that it does. And maybe it does. I doubt it. But who knows? I mean, that's why I'm so excited for trial to come, which, I mean, I'm excited and I'm afraid for everybody involved with that case that nobody's going to be ready for it. And I've been saying that for weeks. So, all right. So paragraph 3, the admissibility of a confession is controlled by determining from the totality of the circumstances whether the confession was made voluntarily and was not induced by violence, threats, or other improper influences that overcame the defendant's free will. And he cites some cases. The same test determines whether Miranda rights were voluntarily waived, Gregory v. State. Thus, the voluntariness of the defendant's waiver of rights is judged by the totality of the circumstances. And then he cites Allen v. State. An express written or oral waiver of rights is not necessary to establish a waiver of Miranda rights. See Haran v. State. Paragraph 4. The Fifth Amendment's privilege against self-incrimination applies to the states through the 14th Amendment. When a defendant challenges the voluntariness of a statement under the U.S. Constitution, the state must prove by a preponderance of the evidence that the statement was voluntarily given. In addition, the Indiana Constitution, Article 1, Section 14, provides that no person in any criminal prosecution shall be compelled to testify against himself. The Indiana Constitution requires the state to prove beyond a reasonable doubt that the defendant voluntarily waived his rights and that he voluntarily gave his statement. Now, if you'll notice, the U.S. Constitution has a lower burden. And what can happen with a state constitution is the state constitution can give more protections to its citizens than provided by the U.S. Constitution. It, however, cannot provide less. So in this situation, the Indiana state constitution has given its citizens more protection. They require a higher burden. Okay. So they require the beyond a reasonable doubt burden that the defendant voluntarily waived his rights and that he gave his statement voluntarily. All right. Paragraph 5. The self-incrimination clause of the Fifth Amendment protects any accused or an accused only from being compelled to testify against himself or otherwise provide the state with evidence of a testimonial or communicative nature or communicative. In order to be testimonial, an accused communication must itself explicitly or implicitly relate a factual assertion or disclose information. Absent custodial interrogation, there is no infringement of the Fifth Amendment rights identified in Miranda and no occasion to determine whether there has been a valid waiver. So let's read that again. In order to be testimonial, an accused communication must itself explicitly or implicitly relate a factual assertion or disclose information. Absent custodial, and he's got that in parentheticals, and remember, that's one of the two things that has to be there in order to trigger Miranda. It has to trigger Miranda. It has to be a custodial. Okay, absent custodial interrogation, there is no infringement of the Fifth Amendment rights identified in Miranda and no occasion to determine whether or not there has been a valid waiver. So the term interrogation under Miranda refers not only to express questioning, but also to any words or actions on the part of police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. Since police cannot be held accountable for the unseen results of their words and actions or unforeseen results of their words and actions, the definition of interrogation can only extend to words or actions on the part of police officers that they should have known were reasonably likely to elicit an incriminating response, and that's Curry v. State. The defense is being held in pretrial detention for his safety pursuant to court order. Okay, inmates of the PLUS program and subsequently correction officers at the IDOC holding facilities have been assigned to observe Richard Allen and record his behaviors, which has included documenting statements by Richard Allen. That the assignment of correctional officers to replace inmate companions coincided with Richard Allen being provided with legal documents for his case. Therefore, it was determined no longer appropriate for inmates to provide companion services due to the gag order and the discovery protective order. That's interesting. All right, 8. That the defendant alleges all his statements subsequent to arrest and should be suppressed for the reasons that they are involuntary due to the conditions of his pretrial detention, which they characterize as illegal coercion, either psychological or physical, in violation of his constitutional rights. Paragraph 9, statements by Richard Allen, which the defense seeks to suppress, are unsolicited and voluntary, like those in Savvy State, where the defendant made unsolicited statement while he was being moved from one part of the jail to the other or to another. Such statement was properly admitted into evidence. See again, C or Savvy versus State. 10, the defense has alleged that physical coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. The defense has also alleged that psychological coercion by state actors has resulted in involuntary statements by Richard Allen that should be suppressed. 11, that the defendant has not alleged that any of these statements are the result of interrogation by law enforcement while in custody, and the state would assert that Richard Allen is not being interrogated by law enforcement or any agent of the state during his pretrial detention regarding the charges pending herein or regarding any other criminal activity. 12, that the case law and the application of the protection of the Fifth Amendment indicates that absent interrogation by law enforcement or an agent of the state, the defense does not have a basis to challenge the admissibility of voluntary statements by Richard Allen. The state acknowledges its burden to show beyond a reasonable doubt that the statement was not obtained in violation of the Indiana Constitution or by a preponderance of the evidence that the state was not obtained in violation of the United States Constitution. However, the state does not believe the constitutional protections allow for the defendant to allege that all statements during pretrial detention are the result of coercion directed against him. This posture requires the court to begin with the assumption that pretrial detention in IDOC, by its very nature, is coercive interrogation by a state actor, and thereby shifts the burden to the state to present testimony to refute illegal coercion for every statement made by the defendant. 14, the defendant is making a blanket argument that all statements by Richard Allen are the result of improper influences based on the defendant's mental state, without having to address each statement and its unique circumstances. The defense's argument ignores the case law regarding application of their cited constitutional protections by skipping over the threshold of showing or alleging interrogation by law enforcement officers or their agents. The defense motion expects the court to accept that all inmates, employees, and third-party medical or mental health professional or personnel are acting as agents of the state, specifically law enforcement, with the purpose of illegally coercing statements from Richard Allen for his prosecution. The allegations and assumptions are absurd, unfounded, and not supported by the motion filed or any of the facts or evidence. The motion to suppress all of Richard Allen's statements is another attempt by the defense to derail this case with the conspiracy theories and inflame the public to believe the government has unjustly pursued charges against Richard Allen. 15, the state requests that Richard Allen be required to identify the specific statements of Richard Allen that were illegally coerced and identify the state actor whose conduct supports the allegations of coercion and describe the conduct they believe to either be physically or psychologically coercive before the state is required to further respond, or is required to respond for further analysis by the court, rather. 16, in absence of the specific allegations by the defendant as to each statement against his interest that is involuntary as a result of law enforcement interrogation, the state asserts that the defendant has not sufficiently identified statements subject to a motion to suppress. Wherefore, the state requests that the court deny the defendant's motion to suppress statements filed on April 11, 2024, as failing to state a claim for relief under the 4th, 5th, and 6th Amendments of the U.S. Constitution, Article 1, Sections 12, 13, and 14 of the Indiana Constitution, absent a more specific statement setting forth with specificity the statements obtained during custodial interrogation by law enforcement or their agent, and identifying the conduct by such state actor that would be psychological or physical coercion illegally and knowingly directed against Richard Allen for the purposes of inducing confessions or statements against his own interest. All right, so there's that. So, I mean, in terms of the legal argument, there really is none. I mean, he cites initially the standard for when Miranda warning is supposed to be triggered. This isn't that situation. This is an entirely different situation. So when we're talking about the law that he cites initially, it's not the right law. It's not the argument. That these are the allegations made in the defense's motion weren't relating to the fact that at least in the first one, because remember there were two motions to suppress that were filed. The second one was relating to the interrogations by Holman. So this particular motion is directed towards the statements made by Allen while he was in IDOC. So, and if you'll recall, and if I wasn't so exhausted, I'd go back and read some of that motion, but it's not happening. Been on lives for 7 hours today, so I'm not doing it. But this isn't a Miranda issue in that particular motion that was filed by the defense. In terms of specificity, I recall there were some rather specific statements that they were seeking to have suppressed. I read them. I think you guys all read them too. And they were fairly specific. And in terms of the conditions in which he was being kept, let's have a hearing. The problem is, again, we're 3 weeks away from trial, less. Do these guys have time to have what would ultimately be at least a half day hearing? I don't know. Can anybody afford not to have a hearing on this? McClellan wants specificity. We know that part and parcel of that filing that Rosie had sought leave of court to um, depose correctional officers, or at least one specifically. I'm assuming that deposition, which would have happened after the filing. I mean, this is where we're at with this case. What my concern is with this case, and it goes to both sides. This isn't the defense alone, and it's not the state alone. It's both. I just have serious concerns that neither party is going to be able to be ready to go to trial on this matter. And when we get to the defense's motion, I get even more afraid that we're not going to be ready for this thing to go to trial. I mean, at the end of the day, remember that this portion of the process, the search for justice, relates exclusively to Richard Allen and his ability to get a fair trial. That's it. That's it. Like, the overarching theme of justice is always there. But this particular portion of the process is all about Richard Allen and Richard Allen alone. And I have no doubt that Rosie and Baldwin are obviously cognizant of that. I have to believe that they're, of the mindset that they're ready to go as much as they can be in such short period of time. Um, but if they're hedging their bet that McClellan's just not going to be ready, and they're waiting, and they're hoping that he's not going to be ready, and they're hoping that he's just not going to be able to put on the case that he would otherwise be able to put on if he had more time. I mean, it's a dangerous gambit. You're relying on the fact that the state can't meet its burden. I mean, it's a scary proposition. If Richard Allen is innocent, and had they taken more time to try to develop the leads that they have from their own investigation, I'm talking about the defense, and they miss out on finding the actual culprit because they rushed it to trial and Richard Allen is convicted, that's a nightmare scenario. If Richard Allen is the guy and McClellan wasn't ready because of the limited time that he had to prepare, and Richard Allen goes free, that's a nightmare scenario. There's no retrying him again. So, I mean, I'm concerned, it's like, and I'm coming from my own personal experience. There was a huge part of me in the case that we handled in Omaha that wanted to make a speedy demand, because we didn't want to give the state 2.5, 3 more years to continue to investigate. We wanted to try to catch them with their pants down, so to speak. It was another big case. It had spanned years. There were just a lot of similarities between the two, but ultimately, we decided that we couldn't do it, that it was just too big of a risk to our client. And ultimately, but I like, that being said, I still sit here today and wonder if we did not make a mistake in terms of demanding a speedy and rushing the state to trial and making them meet their burden. I don't know. All right, so let's jump into the defense's motion. I think this is it right here. It's lengthy. Excuse me. Hopefully my voice doesn't give out. Fortunately, when you're streaming a trial, you don't have to talk the whole time, which is nice. All right. So part and parcel of what we got from the defense was, to me, more shocking, but yet not shocking at all, information that the discovery that's coming in. It's coming in piecemeal, or it's coming in the form of the needle in the haystack, or it's coming in the form that it's being, well, I'll just read the thing. All right. So the motion to compel and motion for sanctions. So you got your preamble there, the intro. On October 28, 2022, the state of Indiana, by its prosecuting attorney, Nick McClelland, charged Rick Allen 2 counts of murder. Mr. Allen's initial hearing was held on October 28, 2022. November 14th, 2022, Rosie and Baldwin entered their appearances on the matter. Paragraph 4, pursuant to 2.5 of the Indiana Rules of Criminal Procedure, the state must disclose and furnish all relevant items and information under Section B2 to the defense within 30 days of the initial hearing, an appearance by the defense, or an appearance by a pro se defendant, whatever is later. And then Indiana Rules of Criminal Procedure 25B2 state that the state must disclose the following information within its possession or control. A, the names and last known addresses of persons who the state intends to call as witnesses with their relevant written or recorded statements. B, any written, oral, or recorded statements made by the accused or the co-defendant, regardless of whether charged or joined, and a list of witnesses to the making and acknowledgement of such statements. D, any reports or statements of experts made in connection with the case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. E, any books, papers, documents, photographs, or tangible objects that the prosecuting attorney intends to use in the hearing or trial. F, any books, papers, documents, photographs, or tangible objects which were obtained from or belong to the accused. And then G, documents produced pursuant to Rule 1.4, the subpoenas, duces tecum, or returns prior to filings. Paragraph 6, additionally, the state has the duty to disclose evidence which is favorable to the defense. Brady v. Maryland, Giglio v. U.S., and then Minnick v. State. The above information was due to the defense 30 days after Attorney Baldwin and Rosie entered their appearance. Therefore, it was due by December 14th of 2022. Now, every state, in terms of the rules of criminal procedure, has like deadlines and numbers like this. I mean, obviously in a case like this, there's going to be things that will be discovered after arrest that there's no way in hell that they would be able to get to the defense in 30 days, especially when it regards scientific testing. Other things obviously can be turned over. You know, police reports should have long been prepared. That stuff should have been turned over. I mean, the bottom line with this 30-day thing is there's what's written in the rule and there's what's common practice in the state of Indiana. Now, I don't practice there, but I hazard to guess that it is not uncommon in major felony cases that discovery is not turned over in 30 days. My point being is that I know why they're listing it in here. I don't know what kind of impact, if any, that will have on Gull, just because, I mean, she's got a felony courtroom. You know, she's gonna. I happen to think that the number itself, in and of itself, will have zero impact on her. She's not going to say, well, it's a technical violation, I am going to sanction McClelland. But let's see what the teeth are in the motion. So the number itself is not something that's going to cause any kind of major disturbance to the judge in this case. The fact that it was long after that. But when we start getting into the facts, when we start getting into the reality of this case, when we start getting into the things that I was so upset about in the middle of this case, which was when his counsel was removed, when I was on fire in this case, when I couldn't believe what was happening on. Like at this point, we've settled more into what I consider to be a typical trial train. You know, we're just kind of plugging along. Motions are getting filed. they're snarky on both sides. Both sides are accusing one another of things. But when you look at everything in terms of how it shook out, in terms of the things that I'm about to read you, it has a different feel. You know, that 30-day date, which I wasn't giving much credence to, it has a different feeling because of how disjointed the representation by Brad and Andy has been. And I continue to argue by no making of their own. They did nothing that was warranted them being pulled from the case. I'm not going to argue it. I win because the Supreme Court says I win of Indiana. I mean, they're back on the case. It's not an argument that I'm willing to have. I mean, the bottom line is she made a mistake when she pulled him off. And in doing so, she completely created a situation where they have what I'm about to read you. So between September 8th in 2023 and October 6th of 2023, 9 months after it was due, the state of Indiana sent the defense 14 hard drives, 5 flash drives, 3 DVDs, and several emails containing discovery disclosures amounting to almost 4 terabytes of information. 9, before the defense had a chance to review all of the late discovery, utilizing only 2 lawyers and 2 non-lawyers, 3 of whom were not able to work full-time on the case, the prosecutor requested the defense be disqualified on October 10th of 2023, and the court entered the defense or ordered the defense to stop working on the case on October 12th, 2023. Accordingly, Mr. Baldwin and Mr. Rosie did not work on the case again until January 19th of 2024. So 10, during that 34-day time frame from September 28th through October 12th, the defense was only able to review a tiny fraction of the massive amounts of discovery that had been dumped on the defense 9 to 10 months after it was due. Paragraph 11, Rosie and Baldwin were reinstated and re-entered their appearance on January 19, 2024. The 2017 extraction and data and the other items of discovery were turned over to the defense on January 30th, 2024, some 11 days after they were reinstated. However, it did not appear to the defense that the hard drives were organized the same as when originally provided during their first tenure, and these changes have caused considerable delay in locating certain evidence, if that evidence can be located at all. And I discussed this, I don't know how many lives ago, that was a concern. Because remember, when they're bumped from the case, they had to turn in all the evidence. They turned in everything that they had. They turned it into McClelland, not to the subsequent counsel. You know, they didn't send it to Libredo and Scremin personally. They turned it to the state, and then McClelland turned it over to them. And so, in the same thing, when they got reinstated, Scremin and Libredo turned it over to McClelland. McClelland then turned around 11 days later and turned it back over to him. What they're stating is that they didn't get it back in the same condition that they turned it over to him, meaning that the work that we had seen in the inadvertent Woodhouse email where they had made an index, you know, they had indexed the discovery that they had, which every defense lawyer is going to do in a case like this where you have voluminous, you're going to try to organize it in some form or fashion. So they're claiming when they get it back, it doesn't seem like it was in the same order and that things are jumbled. So needless to say, they've got to go through everything again. They have to make sure that everything is still there that they had the first time. They have to make sure that things aren't added that weren't there before, and that McClelland is maybe trying to sneak in there, hoping that they won't look and find it. So they've got to go they got to parse it. They got to go through everything. And as you can imagine, with the amount of discovery that we're talking about in a couple of small offices, it's a lot. It's a lot. You know, which again, like when I'm reading this today, you know, when I get to paragraph 11 and 12, I'm like, man, are these guys going to be ready to go to trial? You know, like, I mean, like, and it's not their fault. It's not from their, you know, lack of diligence or working hard. There are only so many hours in the day. There are only so many hours of the day that you can keep your eyes open, unless you're cramming Adderall down your throat and, you know, just running on fumes for days on end, which in and of itself becomes counterproductive. So my fear is that we're hearing this information now, which would seem to indicate that they're still working their way through the evidence. And that's concerning. You know, it just is. It's concerning. Paragraph 12. And again, I practice law. It's not like I look at it differently. I know what it takes to put a case like this together. Like I have a different experience than lay people that have never tried a case. I don't care how much you love true crime. I don't care how many trials you've watched. You just, unless you've done the damn thing, you can't know. There's only one way to know, and that's by doing it. And I'm telling you, I'm concerned. And I have faith in both of these guys that if it gets to the point where they feel like, man, like we gave it our best shot here, but frankly, I think they have a strong argument that the time will toll against the state. That if they have to ask for a delay, if they have to ask for a continuance, it's on the state's dime. Because of this, but like that's where that date, that December 14th date comes into play. It's going to be on the state's time, not the defense's time, because if they'd been timely in turning anything over, 9 months is ridiculous. 30 days is equally ridiculous in a case like this to expect to get all the discovery. 9 months is obscene to be getting things. It's like in a case that's been percolating for years at that point. Like they had their police reports together. They had to have testing done. It's like only the things that would have been collected post arrest that relate directly to Richard Allen are the things that I think are excusable in terms of the state not having turned over in 9 months' time. Paragraph 12. Additionally, it appears to the defense that the state of Indiana has belatedly disclosed tens of thousands of documents spread through many hard drives. For example, the state of Indiana first turned over the hard drive labeled FBI case C7IP blah, 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 blah to the defense on 10/31/23 after Rosie and Baldwin are off the case. And the state of Indiana turned over the hard drive labeled Orion to the defense on 12/7/2023 after Rosie and Baldwin were off the case. After Rosie and Baldwin were reinstated, the state of Indiana turned over those two hard drives to Rosie and Baldwin on January 30th of 2024. Well, the defense should have had those hard drives on or before December 14th, 2022. The defense did not receive those hard drives until January 30th of 2023. I mean, the real question is like, why isn't he turning those hard drives over on January 20th, the day after they're reinstated? Right. Aside from the fact that they're grotesquely late, and I have no idea what's on them, but if it's paper that's been scanned in, it's reports that have been scanned in, they've had this done forever. I mean, like 13, most of the items found on the hard drives detailed are not labeled in any descriptive fashion, and many, if not most, of the items consisting of documents, photographs, and video have zero context as to what the significance of the documents, video, or photographs are. Many of the items are not accompanied by a report or even notes that explain the reason that such items are included in discovery. For example, one video shows a man that appears to be dead on a bed being turned over by what appeared to be police. There is no context provided as to why that video is included in the massive amount of discovery or what this video has to do with the murders of Liberty and Abby. This is just one example of thousands of examples the defense could cite of evidence with no context as to why it is related to this case that the state of Indiana has provided to the defense. So, I mean, dirty pool happens. You know what I'm saying? I mean, it just does. Does it make it right? No. I mean, have I had cases where, but sticking what appears to be evidence from different cases in order to just to bulk up the discovery that they're turning it over makes it seem like they're trying to hide something or just trying to make it that much more difficult for them to be able to get through everything in a timely fashion. It's probably the second thing. It's probably just trying to create a log jam in terms of time, in terms of having to go through shit that doesn't matter, that's not relevant, or apparently is not related to the case at all. But again, I'm not privy to the discovery. I don't know. I don't know what it is, but it sounds like I said, it's that needle in the haystack thing, where they're trying to go through massive amounts of discovery in order to try to find things. I mean, like, I have to assume that a video that appears to be a dead guy in a bed being turned over by cops has nothing to do with this case, right? I mean, doesn't sound like it fits the case at first blush. All right, 14. Additionally, more recent evidence that the state of Indiana has turned over to the defense through e-discovery contains evidence that is seemingly sandwiched in the middle of completely unrelated discovery. For example, the state produced one e-discovery response received on March 15th of 2024, which included a document labeled Second Half of Delphi, 3 subs, consisting of 341 pages of documents. Most of the contents in this document are reports from Westville Correctional. However, buried among these other reports is a narrative report on page 239 by Detective Vito of the Indiana State Police describing a phone call with the Detective Liddell of the Manatee County, Florida Sheriff's Office detailing an investigation of a third-party suspect known by the Unified Command in this matter. Detective Liddell told Detective Vito that the Manatee County Sheriff's Office sent a tech to obtain a pair of suspects' jeans that appeared to have blood on them, and that the Manatee County Sheriffs would send the items to the Lafayette, Indiana State Police Post. Additionally, Liddell sent the email to Detective Vito with the report and a statement affidavit. Vito noted that both the documents were attached to the report. Neither the Manatee County, Florida report nor the statement affidavit were attached to the documents the state of Indiana provided to the defense. The defense has not located any of the follow-up discovery detailing whether the state of Indiana even attempted to test the blood on those pants for DNA or does not know if such a report exists. And if it does, whether it may be found sandwiched in between other discovery. This is just another example of the discovery issues plaguing the defense. This document would not have been found but for someone taking the time to go through this discovery one page at a time. I mean, are they implying that Manatee County video, that this third party thing with Manatee has something to do with this case? I mean, it seems like it. I mean, we know Vito worked the case, but they're talking detailing an investigation of a third-party suspect known by the Unified Command. I mean, that would insinuate to me that it, of course, is associated with this case. But then and again, like every paragraph I read, it creates like a huge pit in my stomach. Because frankly, this thing reads like a motion to continue the trial is what it should be. Like, honestly, they clearly have not been able to get through all the discovery, and like getting through the discovery just to get through it, to make sure that you have everything is not the same as preparing for trial. It's like, man, I know what they're trying to do. I do. I really do. I know what they want to do. I just don't know. I don't know. I'm worried about it. I'm worried about it from all sides of it. I mean, this trial could turn out to be a shit show. Like make the pre-trial process look like child's play. I mean, they got to be ready. Everybody's got to be ready for this thing. Like the judge is going to come hammering that gavel, ready to go to trial. State's going to have to put its witnesses on. Defense got to be ready to cross them. All the evidence has to be ready to be presented. All the whatever they're going to use. If they're going to use, demonstrative evidence that's via slideshows, whether it's like whatever, like all of that has to be prepared and ready to go when that gavel hits the bench. 15. Furthermore, the state of Indiana has sent repeated piecemeal discovery, forcing the defense to engage in time-consuming process of reviewing and attempting to search multiple hard drives, flash drives, and e-discovery for particular documents the defense believes exist but cannot locate. The state of Indiana has drowned the defense in late discovery disclosures, which materially harms the defense team in preparing for trial in a meaningful and cohesive way. Liberty German cell phone. Paragraph 16, on February 15, 2017, Lieutenant Brian Bunner of the Cyber Crimes Unit of the ISP conducted an extraction of data from LG's phone using a program called Cellubrite. Said information was downloaded via Cellubrite, and several reports were generated therefrom. 17, when the defense was unable to locate the discovery from LG's phone, it sent an email to McClelland on June 17th of 2023 requesting a copy of that data from LG's phone, as it had not been yet provided to the defense. 18, clearly the state of Indiana possessed the 20 of 17 Cellubrite extraction and the data on the date they filed the charges against Mr. Allen, which is October 28th of 2022, as well as when the defense requested the data from LG's phone in its June 17th of 2023 email. Despite the state of Indiana's possession for over 5 years when charges were filed against Allen, on October 28th of 2022, the extraction of the data from LG's phone was not provided to Mr. Allen's attorneys until September 8th of 2023, 9 months after it was due to the defense. However, even upon receiving the extraction and the data from Liberty's phone, the defense was unable to immediately focus on that important piece of evidence, as that evidence was just one small part of a larger series of evidence dumps that the state of Indiana chose to turn over to the defense in a roughly 4-week period between September 8th of 2023 and October 6th of 2023, more than 9 months later than the required by the Indiana Rules of Criminal Procedure. Included in the 2017 Cellubrite extraction of Liberty's phone was a video purportedly taken on February 13th, 2017 at 2:13 p.m., containing images of Abby and a purported suspect. The state of Indiana failed to produce this extraction to the defense until September 8th, 2023, 9 months later than the discovery rules mandated. Additionally, in 2019, ISP, perhaps with outside assistance, conducted additional extractions of LG's phone utilizing different software programs. These newer extractions have been discussed by the ISP officers in depositions, but has not been located in any discovery provided by the prosecutor in any usable fashion. The defense has requested the state of Indiana to provide locations of these newer extractions. Additionally, a certain extraction software called Axiom has been provided to the defense. The defense has been unable to open said extraction, but apparently needs some type of special license program in order to open the extraction. The defense believes the state of Indiana has not provided the special program. As part of the reasonable investigation, the defense would have wanted the opportunity to compare the 2017 extraction to the 2019 extraction to see what differences might exist and the reasons for those differences, and would have further wanted to exercise that opportunity on or before December 14th, 2022, when the state of Indiana was required to turn over all the extractions of LG's phone, so the defense has had time to, as much time as possible to analyze Liberty's phone extractions, and also to turn it over to their own expert, both extractions. You have to turn this kind of data over to your own forensic phone experts so that they can do their own extraction and or come in produce their own extractions from the devices themselves so that they can prepare their own reports. You can't just take it on faith that law enforcement did the job right. I mean, that's the whole point of having experts, is that you can conduct your own analysis and testing. 24, there is no justification for submitting the 2017 cell phone extraction or any other of the extractions and data 9 months after they were due to the defense, especially when the state of Indiana had the evidence in its possession for almost 6 years prior to charging Mr. Allen. Assistant Rushville Police Chief Todd Click letter report and evidence. We all know about this thing, the famous Click letter. 25 containing these disclosures was the letter in the 83-page report prepared by Click, which was sent by certified mail to McClelland on April 28th of 2023, which obviously, like, there's an example. Like, so that's after the December 14th day, right? So clearly McClelland couldn't have turned that over till at least April 28th. But let's see when he actually turns it over. McClelland signs for the letter on May 1st, yet inexplicably, McClelland did not disclose this highly exculpatory report, nor the accompanying exculpatory videos and the other related discovery to the defense until September 8th of 2023, 4 months after he received it. Rule 3.8D of the Rules of Professional Conduct, Special Responsibilities of a Prosecutor, states that, quote, the prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. The prosecution should have turned that material over to the defense immediately upon his receipt of same. 26. There is no justification for Prosecutor McClelland to delay turning over the Click report for over 4 months after the Carroll County Prosecutor's Office received it. 27. The delay in disclosing the Click report and evidence to the defense has resulted in harm to Mr. Allen. Had the state of Indiana turned over the Click report, videos, and documentation in a timely manner, the defense would have focused on certain third-party suspects much earlier in their representation and would have then investigated the case much differently and much more efficiently. I mean, like, when I read that sentence, does not give me the warm and fuzzies. Like, this is what I'm saying. Like, if this is something that they can do still, and that means that they have to ask for a continuance to get the trial kicked a bit, like this, like, it's not about pride. It's not about ego. It's not about, look, see, I told you it was all game. They never wanted to go to trial. No one gives a shit about that. Like, all you care about is your client. And I guarantee you that's all that Andy and Brad care about, is their client. But when I read this, focus on certain third-party suspects much earlier in the representation and would have then investigated this case much differently and much more efficiently. It scares me. It just does. B, change the order of deposing witnesses and would have deposed certain witnesses such as Elvis Fields, Brad Holder, Johnny Messer, Rod Abrams, Ned Smith, Patrick Westfall, Taylor Hornaday, and much earlier. C, ask different questions of law enforcement at their depths. D, been better prepared for trial earlier. In terms of Mr. Allen's imprisonment and the early trial considerations. The fact that Richard Allen remains trapped in solitary confinement in the secured housing unit of both Westville Correctional Facility and the Wabash Valley Correctional Facility while on pretrial detention has caused a physical and mental deterioration of Mr. Allen, causing defense counsel to seek a speedy trial rather than risk their client facing further mental and physical deterioration. So there's our answer, right? Like, there's our answer. So, I mean, what should be going on is that they should be making a motion, number one, to continue the trial, but part and parcel of that, to put Rick Allen on house arrest, have him sit at his house. It's on the state's dime. All of this has been the state's fault with respect to the slow play of discovery. It's within his rights to ask for a speedy trial. What you can't have is the defense deciding, okay, well, we're going to abandon our client's right to a speedy trial because the state hasn't gotten us our discovery. We can't go to trial because they haven't given us the discovery. Well, there's got to be a repercussion to that. And to me, a proper repercussion would be, okay, well, we're going to make a motion that Rick Allen is on home confinement. And we're going to ask to kick the trial. If they're concerned, which I believe them, that their concern is that Rick Allen will make it to a trial, will actually survive to make it to a trial. If that's the concern, I think that's the remedy. And I'm hard pressed to understand why Gull wouldn't grant it. Now, I'm sure that people are going to be losing their minds. Oh, he's an alleged child killer. He's innocent until proven guilty. And frankly, home detention, they'd have somebody sit on him constantly. Somebody 24/7 just sit on the house. Plus he'd have his bracelet. It's not going anywhere. Are they, what is the counter argument? They're afraid he's going to kill himself? I don't think so. 29, the fact that the state of Indiana has violated rules of discovery through very late disclosure of large volumes of evidence, including evidence that supports the theories of innocence, has put the defense in a precarious position where it could have, one, kept the October 2024 trial date and then spent the next 6 to 8 months reviewing late evidence that the state of Indiana had in its possession at the risk of continued deterioration of their client's physical and mental well-being, or seek a speedy trial and hope that they could put the case together in spite of the significant discovery violations perpetuated by the state that have put the defense at least 9 to 10 months behind where it should have been had the state of Indiana followed the rules. See, I mean, like, the thing I worry about, like, it's a solid argument, but if I'm Nick McClelland coming back on this, my response is going to be, okay, but you told us leading into the whole ambush with the leak stuff where you got bounced, you told us that you were ready to go to trial in January. Like he's gonna make the you can't have it both ways argument, I anticipate. Because if they were ready to go to trial in January, and I imagine Gull gave them the same pushback. All right, 30 as a basis for understanding the impact of solitary confinement for even 2 weeks on a human being, let alone 16 plus months. The defense cites the United Nations finding on that topic. The UN standard minimum rules for treatment of prisoners, rules 43 and 44, prohibits the imposition of solitary confinement for prolonged periods, defined as periods of 15 days or longer. Additionally, per the UN standard, solitary confinement should be prohibited in the case of prisoners with physical or mental disabilities when their conditions would be exacerbated by such measures. And they cite the reference. 31, the decision to seek a speedy trial was not hastily made, but only decided after factoring in that Richard Allen had been languishing in solitary confinement for well over a year, approximately 536 days or 521 days longer than allowed by the United Nations, which equates to more than 20 times the standards set out by the UN, and continues to suffer both mentally and physically. The defense fears that delaying the trial will result in a continued and prolonged mental and physical trauma to Richard Allen, or even worse. Choosing a speedy trial and dealing as best as it can with the fallout from the state of Indiana's late discovery disclosures was and still is a better option than risking Richard Allen's well-being by prolonging the trial date to October. Man, what a balancing that is, like, to try to figure that out. To try to figure out if taking the risk of going to trial on a speedy, potentially not being prepared, admittedly, not being prepared how they want to be, in the hopes that the state is also not prepared how they need to be in order to meet their burden. And, because this argument, which is compelling, because you do have to worry about Richard Allen in there. I mean, like I've said it, they don't give a shit about the word alleged in prisons. The guards don't, the prisoners don't. The word alleged child killer is not something that they care about. In the eyes of everybody in those institutions, he's a child killer. So like the fact is it that there's probably truth to the fact that they have to keep them segregated or move them to a section where it's got convicted felons, people that have already been convicted of crimes that he's been alleged to have committed. I still don't know if he's safe there. And that's not even taking into account the massive psychological damage that's going on with being held in isolation 23 hours a day for years, year and a half. I mean, I don't know what the right answer is, to be honest with you. I mean, I see why they're doing it. But if he gets convicted because they went on a speedy and they weren't ready, he's in a worse situation. Then he's a convicted child killer. And, and if he's innocent and they rush to it, he's not going to make it in there. And if he's innocent and they could have shown it, if they could have ferreted it out, if they could have investigated, is their duty. I've explained this to y'all. That is their duty as defense counsel. We have a duty to investigate the claims against our client. And these guys have real leads. They have leads that other cops, legitimate cops, believe have legs. Man, it's like another Hobson's choice. It's like they feel that they have no choice. They feel adamant that if they keep Rick Allen in there, that he's not going to make it to trial, that he wouldn't make it to October. And they know better than any of us, including his wife. I mean, they're the only ones who see him, aside from the correctional officers and the inmates. Like, I mean, no one else knows what's going on with this guy. I mean, because they have enough right here to get a continuance. Like Gull would have no choice, I believe, but to grant the continuance, even at this late hour. All right. Request for sanctions. As a sanction for the belated disclosure of the report drafted by Assistant Rushville Police Chief Todd Click, the defense requests that the jury be instructed that Chief Click's report contains evidence tending to prove the innocence of Mr. Allen, and that the prosecution failed to turn over that evidence to the defense in a timely manner. Further, the defense requests that the state of Indiana be excluded from rebutting any information presented by the defense and contained in Assistant Click's report and accompanying videotape statements. And as a last sanction for the delayed discovery of the Click information, the defense requests that it be able to play the late discovered video evidence of any witness it chooses to the jury without objection from the state of Indiana, foundationally or otherwise. So that'll be denied, denied, and denied. All three of those things. There's no way she's agreeing to any of those. 33. Indiana Trial Rule 37.2b states that if a party fails to obey an order to provide or permit discovery, the court in which the action is pending may make such orders in regard to the failure as are just, including prohibiting it from introducing designate matters and evidence. 34. As a sanction for the late discovery or non-discovery, Mr. Allen requests that all data from LG's phone, including videos or all data extractions, be excluded from evidence. So we're trying to keep Bridge Guy video out. It's not happening. I mean, none of these things are happening here. None of these sanctions. I feel very confident in telling you that. All right. Let's see. Where was I? 6. I went backwards. Okay. Motion to compel. Additionally, the defense believes that there are multiple documents which still have not been disclosed to the defense, or the defense cannot locate in the massive discovery provided to the defense. This includes the following. A, on November 4th of 2019, the state of Indiana sent a geofence warrant to Google requesting activity from any device in a specified distance and within a specified time of the area in which the bodies of Abby and Libby were located. On the same day, it appears Google returned data in a spreadsheet which contains 18,632 lines of data, each relating to a particular device ID. Generally, there is information received in follow-up requests which identify subscriber data with device IDs. To date, no such spreadsheet or data has been located by the defense, nor can any such information be found by the defense in spite of requests to the prosecution. B, Detective Murphy testified in his dep that law enforcement had pings and other phone information related to Elvis Field's phone on 12/13/2017. To date, no such data has been located by the defense, or the defense cannot locate the information in the massive discovery dump despite good faith efforts to locate said evidence if it exists. C, SOPs for the evidence collection and retention for ISP, Carroll County Sheriff's Department, and Delphi Police Department. To date, either no such documents have been, that's standard operating procedures if you don't know what SOP is. To date, either no such documents have been provided or the defense cannot locate them in spite of requesting said information from the state of Indiana. D, chain of custody documents related to the bullet purported found near the bodies of LG and AW. To date, no such data has been located by the defense, or the defense cannot locate that information despite of requesting said information from the state of Indiana. So they're saying they don't have the chain of custody documents pertaining to the state's strongest piece of evidence against Richard Allen. Chain of custody documents related to the sticks, branches, and bark found at the scene. To date, no such data has been located by the defense, or the defense cannot locate that information in spite of requesting said information from the state of Indiana. F, the defense possesses photographs of the bullet purportedly found in the ground near the bodies of Libby and Abby, and photographs of the bullet at the crime lab. The defense has no other photographs or video of the bullet from any other time. This is the chain of custody. In the event that additional photographs or evidence, or videos rather, the defense requests they be immediately produced. To date, no such photographs have been provided to the defense, or the defense cannot locate said photographs in spite of requesting from the state of Indiana to point out where said photographs are located in the discovery. If no such photographs exist, then the defense would request the prosecution affirmatively state that no such photographs exist. I mean, that's all part of chain of custody, like the photographing, and telling you where it's going from person to person, everybody who has hands on it, signatures, initials, all that stuff. Prior to October 19th, 2023, the state of Indiana previously provided the defense a number of PowerPoint presentations which were titled Executive Brief of Summaries, which appeared to be presentations providing information to law enforcement during briefings, including a PowerPoint presentation connecting Elvis Field's Delphi. To date, since getting back on the case, no such data has been located by the defense, or the defense cannot locate the information in spite of requesting said information from the state of Indiana. H, according to certain law enforcement officers involved in the investigation who have been deposed, members of the FBI, BAU, were present and engaged in the investigation of this crime. References have been made to the BAU report. However, the defense has not been able to locate any reports from the BAU agents or any other law enforcement concerning assessments of the crime scene regarding Odinism, Nordic culture, or paganism, Germanic culture, runes, magic, cult activity, or heathenism. To date, no such data has been located by the defense, or the defense cannot locate the information in spite of requesting said information from the state of Indiana. On October 6, 2024, pursuant to Indiana TR 26F, Defense Counsel sent a letter to McClelland via certified mail and email requesting the above information, paragraphs 36A through H, or the identification and the location of the information in discovery if it had been previously discovered. Furthermore, Defense Counsel requested a response by April 19th of 2024. So in its April 16th, 2024 certified letter to the prosecutor, the defense requested that Prosecutor A explain his reason for failing to turn over the exculpatory click information for 4 months when that Brady material should have been turned over immediately to the defense upon receipt. 2, explain his September 6, 2023 email in which he made false claims and misrepresentations to the defense concerning the identity of a Purdue professor and law enforcement's attempt to locate said identity, even going so far as telling the defense that the state of Indiana may not be able to learn the identity when at the time of the email, the identity was already known. 3, explain the reasons for dumping 14 hard drives, 5 flash drives, 3 DVDs, in certain discovery 9 months later, and then required under statute, or 9 months later than required under statute, thereby putting the defense at a distinct disadvantage, especially while dealing with their client's mental and physical health issues, which propelled the request for a speedy trial. Okay, the defense requested the court to order the prosecutor to explain his conduct around the issues raised in paragraph 37. Okay, 39. State of Indiana has made no substantive response to the discovery deficiencies outlined in the defense's April 16, 2024 letter, nor has the prosecutor attempted to address the issues outlined in paragraph 37 herein. 40, additionally, in early April, the defense requested prosecution to provide Brady Giglio material, if it exists, concerning certain law enforcement officials, both state and federal. The defense provided a deadline of April 15th for the Brady Giglio material, or Giglio, it depends on how you pronounce it, then extended the deadline to April 19th, 2024. To date, the prosecution has failed to provide any Brady Giglio material, nor has the state of Indiana indicated that no such material exists. The defense believes that at least one key member of law enforcement has Giglio Brady material that the state of Indiana has still failed to turn over to the defense. Wherefore, Richard Allen, by counsel, respectfully requests the following. A, that the documents be produced by to counsel for the defendant by 5 p.m. on Friday, April 25th, so 3 days from now. The state of Indiana be ordered to turn over Brady Giglio material to the defense by 5 p.m. on the 25th. C, the state of Indiana be sanctioned for its discovery violations in the following way. This court will instruct the jury that the prosecution received certain evidence that tended to exonerate the defendant on May 1st, 2023, but failed to turn over that evidence for over 4 months, and that said failure to timely produce that evidence to the defense was a violation of the rules. Permit the defense to play any video that was belatedly produced without objection from the state of Indiana. Prevent the prosecution from abutting the evidence that Todd Click provided to the prosecution on May 1st, 2023, and then prevent the prosecution from using any data or information extracted from Liberty German's phone in its evidentiary presentation. So this paragraph 2, permit the defense to play any video that was belatedly produced without objection for, like, I'm dying to know what that is or what those are. Clearly they have something that is either hearsay that they want to be able to play, and they haven't been able to figure out a way other than probably putting Rick Allen on the stand to get it in. So this is the ask here. I'm dying to know what those are. I'm dying to know what they are. Obviously, they're concerned about the bridge guy video. You know. All right. So D, that the prosecutor be ordered to explain in written form his reasons for delaying turning over Todd Click evidence as detailed in paragraph 38 above. The reasons why he sent the email. That it is filled with false statements and that misled the defense, and the reasons he failed to turn over massive amounts of evidence, but then chose to turn over that evidence to the defense between September 8th of 2023 and October 6th of 2023, just 4 days before requesting the court to dismiss defense counsel from the case. This request is made for several reasons, but especially to preserve the record. And then for all their just and proper relief in the premises. That's signed by all three, Jennifer Auger, Brad, and Andy. Well, look, man, I'm not trying to be like a Debbie Downer here. I'm really not. Like this isn't emotion that gets me all riled up and psyched up because trial's 3 fucking weeks away. You know what I mean? Like this, like if I'm reading this and trial is in October, then I'm getting all riled up. When trial is less than 3 weeks away, I even wonder if Andy or whoever drafted this had the time to be drafting this instead of looking through the discovery. I mean, it's a legitimate question. You know, like I have to be honest. Like if I'm those guys, I am trying to think of a workaround, and the best workaround that I can see, and I have no idea whether or not Gull would grant it, but it's not an unreasonable request, and that is to put Rick Allen on home confinement. If that requires that law enforcement have somebody staged outside of his house, so be it, and that he's released pending trial. That's the punishment for the state pulling this shit. You know, that takes the flight risk out. Theoretically, it takes the concept of him harming others or himself out. I don't think Rick Allen is suicidal. And that keeps him in the house so he can't hurt society. If in fact, that's the type of person that he is. And then we can allow for this trial to be prepared for properly. I mean, the question is, can they file the motion asking for a continuance only with the stipulation that they're only asking for it if she grants home confinement to get him the hell out of IDOC? You know, I mean, like we all know, there's no way in hell Gull's granting that. The day that Gull allows Richard Allen to walk out of IDOC with a bracelet on his leg and go to his house and chill until whenever a date would get set, this is the day that hell freezes over. You know, so that brings us right back to where we're at. That brings us right back to the ultimate question. You know, and I don't know. I don't know what the right answer is. You know, as much as people think that, I'm like in cahoots with the defense, I assure you I am not, at least not in the sense that I'm working with Brad and Andy and that I'm privy to discovery. I have no idea what's going on there. But I could tell you this, it worries me massively. Like I'm really, and it should worry everybody out there listening to this. It should. Like I'm not trying to be, like I said, like a Chicken Little, the sky is falling dude here, man. I'm telling you, it's like I'm not getting the feelings of rage because trial is here. It's like the time for rage has come and gone. Like now it's like the time for like abject fear that no one is going to be ready for this trial when it hits on the 13th of next month. And I mean, like everybody needs a fair trial here. Everybody needs competent counsel on both sides of this thing so that it's done properly. And I don't know if it's logistically possible at this point. I just don't know. Based on what I just read, if I was to go strictly off of what I just read in this motion, I would say not a chance. And I mean that's not even to speak to like all the motion work that needs to be done. Like the motions in limine I was talking about there's so much that has to be done in the next 3 less than 3 weeks. It's mind-blowing. All right, I'm going to see if we have I've been going an hour 37. I want to see if I've got any questions. Not one question. All right. Let me see if I got any in the live comments. All right. Let's see. Man, I should have put a brick on the comments. I forgot to do that. Mandy, I always want the 15-second delay on comments. If I forget to do it, can you check to make sure I do that moving forward? It's not, it's gonna take me a half hour to scroll down to the bottom of these things. So I don't know what you guys are feeling out there. It's impossible for me to go through all of the potential comments. But you know, I'm very nervous. I'm nervous that these guys have not been given the time to go through their discovery, and that because like I said, dirty pool is played in cases like all the time. Like that's not unusual. It's just not something that is like unusual. The problem is that we've got trial. Like we've got trial. And if Andy and Brad are adamant that Alan's not going to either physically make it alive to a trial or that his mind will be just mush, or to the extent to where they're not comfortable taking the time that they need to get properly prepared. I mean, that something, man. I mean, I'm glad they made the record of it. I am glad that they like the most important thing. I guarantee you, Brad or Andy doesn't think any of this stuff is going to get granted by Gull, but I'm glad they made the record of it. I'm glad they made the record of it, because if he's convicted and they go up on appeal and they see what went on here, I mean, like I said, I think it's a scary proposition. I really do. And as far as, let's see, what's Sloty say? I think if they put it out a year, it still won't matter because Nick will continue to withhold discovery. I mean, that could be true. I mean, like the problem is that is the judge. It is literally the judge's job. Because what's supposed to happen is that the judge starts telling the state, okay, if you don't turn the shit over, I'm going to bar you from like putting certain evidence in. She's got to start threatening the state. Have I seen discovery that's been managed like this before? I mean, not like this. I mean, I've 100% had discovery slow played. I mean, I've had cases where I've believed that they've withheld Brady material. I mean, it wasn't to the same extent in in the Garcia. And the reason that I always bring up Garcia in relation to this, because I've read like some snarky comments that I talk about a case that has nothing to do with it, is because they're almost identical, like in every single way procedurally. That's why I bring it up, because it is a perfect example that we actually went through almost the identical shit that they went through and that they're going through in this. And there, the battle for us was trying to get the phone records of the Brumbecks that we just could not get, because in there was a question as to the time of death, whether it was Sunday or Monday or Tuesday, because the bodies weren't discovered until Tuesday. And they needed their timeline to stick because Garcia was alibied by 7:30 at night in a different state, and we just were desperately trying to determine whether or not they had made or gotten any phone calls. And like they would only turn over like 2 of the cell phone records. We never were able to get the landline ever. And these were old folks. They used the landline. This was back in 2013. I mean, this, like, I had not read this motion because I was streaming all day. So you're kind of seeing my like guttural response to this, reading it in real time. I am not getting the warm and fuzzies on this. like no one should, like anybody who's like enraged, yes, but like the enraging portion of this, like, it doesn't matter at this point. Like the only thing that matters is this thing is set for trial in 3 weeks. And are they going to be ready to go to trial? I don't know. And I'm talking about all of them. All of them. I mean, remember, the defense doesn't even approve a goddamn thing. Nothing. That's the state's burden. They don't have to put anything on defense. I mean, naturally, they've got issues that they have to deal with. They've obviously got to deal with confessions. They've obviously got to deal with the unspent casing. They've obviously got to be able to handle, these witnesses who claim that they saw somebody who may have looked like Richard Allen on the bridge, man. I mean, but to me, the biggest 2 things are obviously the confessions in the casing. They've got to be able to deal with those things. And maybe they have enough time to do that, but they're certainly not going to be able to put on any kind of substantial case with respect to third party liability or culpability. There's just no time to do it. There's no time to do it. It's like, like I'm dying to know. Like I want to know what this Roman numeral 2, I permit the defense to play any video that was belatedly produced without objection from the state of Indiana. I guarantee you that those are like all videos that are hearsay, that are probably videos that are of Brad Holder, Elvis Fields, Johnny Messer, and Patrick Westfall. And they're all hearsay. And how do you get those in? It's like, it's got to be some shit like that. That's part of like the puzzle. That's part of the chess game of being a trial lawyer. You guys and people that don't understand how trial work really works is that you are a vast majority of your time is trying to figure out how to get certain things into evidence, because the rules of evidence, that's everything. That's everything in a trial. And you have to figure out how you're getting certain things in, because there are rules, hard, fast, bright line rules of evidence. So let's see. The state was relying on false confession and a plea deal. State knows if all the discovery is turned over, Richard Allen will surely be acquitted. This wasn't supposed to go to trial, in my opinion. I mean, I hope you're right. Presuming that, if Richard Allen is innocent, I hope to God you're right on that. I mean, I see so many other creators like saying he should take a plea deal. I'm like what sense do you get that either these lawyers or Rick Allen buying through his attorneys has even an inkling of making a plea deal on this case? Like, talking about not being able to read a room. Like, there's no chance that Richard Allen is taking a plea deal on this. Zero. There never was. Need some Z's. Did you make that just for me? Question: would a normal judge grant these things or a continuance? They're not asking for a continuance. That's the thing. This isn't a motion for a continuance. I think that Gull would grant a continuance. I do. What they're saying is that they are terrified that they have waited, that we either risk Rick Allen being murdered in prison or going completely off the rails mentally to the extent where he can no longer assist in his own defense by keeping him in solitary, or we're forced to go to trial not prepared. You know, I mean, it's like they're going to do the best they can. I mean, like, again, they don't have the burden, but shit, man. You know, I mean, they've put it out there that they've got a theory of defense that might have legs, but they're just not going to have the time to flesh it out. There's no way. I mean, I don't know who drafted this. It reads like an Andy. It reads like an Andy motion. Andy likes to drum down those dates. He likes to repeat things for effect. It reads like an Andy motion, but I mean, this took him hours and hours and hours to draft this motion. You know, when would time more, but he had to make a record. Like, time would have been better spent in a perfect world. Do you think Auger really drafted it? I know she's got the first line signature, reads, then she writes a lot like Andy T. Hi, T, by the way. She writes a lot like Andy Baldwin. Surprisingly. So I don't know, y'all. I don't know. No, I'm not sunburned. It's probably this whack light of mine, or like I'm having a stroke or some shit. I don't know. I don't feel like I'm stroking out, but so let me see if I got anything else. No, I can see the signatures, y'all. I see what the signatures are. What I'm telling you is it reads like an Andy Baldwin motion. Read them. I read them all. It reads just like Andy. It reads exactly like Andy writes. Like, if you read a Baldwin and a Rosie, I can tell them immediately. And maybe Auger did write it. Maybe she did. I know she signed off on it. You know, that could have been like, hey, Baldwin saying, all right, well, Gull hates me, so you sign off on it. I mean, we do it all the time. Like Allison, like I've signed off on Allison's, it's the same office, same attorneys working on the case, or it's collaborative, one of the case. But I'm telling you, it reads like an Andy. All right, let's see. Got anything else? I don't know anything about the fundraiser. I know that there's a brick on it right now. That's all I know. I know that Stripe was not working with that Pay to It or whatever that app was, or that website was. Like that, like their terms of service said that they were no longer, Stripe was no longer working with crowdfunding shit. That's all I know. I don't know. Does anybody else know? I haven't seen anything about, I know it's been stuck at like the 40,222 or whatever it is for a hot minute. Let me see if there's anything else. So yeah, as far as like Nick's filings, again, I think the first one is kind of stunning. I mean, throwing a cop under the bus, or throwing a prosecutor's office under the bus potentially having them, that office, that prosecutor's office, have to reopen God knows how many cases if it turns out that there's some legitimacy to that. If not, it was just a shitty move, like a slimy move by Nick. Another move to just destroy the credibility like they did with Andy and Brad by getting him bumped from the case. I don't know that they'll ever be able to recover from that. Like from the people on the other side of it, they think that Brad and Andy are the biggest pieces of shit clowns that they've ever seen based on a narrative, an incorrect narrative by the state. And that was fortified by the judge when she removed them from the case improperly. It doesn't matter that they're back. You know, it's like perception is everything. And this is like the shit that they pull with Allison again in you know, the Garcia thing, when they said that she filed a motion for sanctions against her, saying that she was harassing and intimidating the Star's material witness, which was a complete lie, complete fiction. That little motion disappeared into the ether after I was screaming and yelling that Don Klein owed a public apology to Allison for impugning her integrity. You know, it's like you can't unring those bells. Like these are moves. These are media moves. These are moves that are made so that the media is going to report on this. Now it's going to go out there that Todd Click's like, you know, potentially a wacko with mental illness problems, and that he was withholding exculpatory evidence on his cases. So he can't be trusted. I mean, like what is the ramification to Nick McClelland if that comes back and that's all a bunch of bullshit? Is this guy allowed to just continue to go out and flamethrow everything in order to get a conviction on this case? He's going to flamethrow Allen's attorneys because they're actually doing their job. He's going to flamethrow who they know will be their star witness by saying that he's withholding exculpatory evidence in cases and that he might have mental illness problems, and I need to check it out. Like whether or not it's true or not, like he made the language slippery enough that he's not going to get dinged. He could be like, well, I heard it. It was a word on the street type shit. I heard some dudes were telling me down in Rushville that they heard from this other guy from around the way, you know, up down the street, that he called from a payphone and said, Nick McClelland, hey man, listen, that Todd Click sucker, he was, you know, I mean, some bullshit like that. He's got really slippery language in there. He's not going to get him pinned down. Same with the mental health stuff. All he needed to do was get that out there. Like who lives in Indiana? Like, I want to know, people that live in Indiana, have they been reporting on this tonight? Have they been reporting on this? Like, has this been like a story in Indiana on the news about, you know, defense star witness Todd Click under, you know, I mean, like I'm curious. And as far as Nick's second filing, it had no substance at all. It was a typical Nick filing, cited the wrong, like it has no, like that motion has nothing to do with Miranda. That's the second one, Nick, not the first one. The first one was about his conditions and his mental health, and it's like a civil rights violation type thing, man. It's not like that they were saying that he had to be read his Miranda rights. Kidding me? I mean, it's like, I don't know. All right. So coming on 2 hours. I love y'all. I thank you so much. At this point, at this juncture, for all of you that hate when I thank people, you might want to dip because I'm doing it. Because I don't care if you hate it or not. It's respectful and it's what I do. And I'm never going to not thank people for being generous with me. So it drives me nuts. Like, he's a lawyer. It's not, he's begging for money. I'm like, dude, what? Like, do you get gifts and you don't thank people? I don't give a shit what you do for a living. That's just being a human being. Like, there's one person that I'll never not think of that comment when that person was like, it was like in a Reddit. I should stay out of Reddit, except I love Delphi docs. It's such a great Reddit. It's such a great sub. All right. So yeah, if you want to bounce, I'm about to give the thank yous. You should wait. Like, and if you're one who was gifted a membership, maybe you hang around and hear. In all fairness, what's the ramification for you spouting this viral support to defense if indeed it's all true? In all fairness, what's the ramification for me spouting this viral support to defense if indeed it's all true? I'm not on the case, dude. I'm not trying. I'm not one of the lawyers. I'm not Nick McClelland or Andy Baldwin. What are you talking about? What's the ramification for you writing that comment? If what's all true? What do you mean? If Click, the ramification of if everything's true about Click is that he'll be a pretty bad witness. That's the ramification, right? All right. Let's see. Casey at the bat, new member. Family hug. Love you. Thank you. $10 holla from Debbie, always giver. Appreciate you. Casey at the bat comes back again, gifts 5 DD memberships. Thank you so much for that. And I'm sure all the members that are newly minted are very thankful to you as well. Thank you very, very, very much. Were Sister and his Elvis, I don't think Elvis was deposed, and I don't think that I don't know, honestly. It sounds like they had mentioned in the motion, it sounded like they had at some point, I can't remember. Sleuthy, if you're still in here, did they say that they deposed Holder and those guys? I can't remember. I read something about it. I can't remember if they did. Yeah, I don't know. Unfortunately, I can't remember. I read something about it. Sorry, Freckle Joy. Thank you for being a member for a month. Charmaine, gifted, always giver, mod, wonderful, love you. Thank you so much for your continued generosity. Family hugs, member for 6 months. OG, Persephone, always giver, gifted 5 Defense Diary podcast memberships. I mean, you guys, I love when you spread the love. It means so much to me, and to build a community. Really, truly. AKA Radar member for 2 months. You know, I adore you. I think you've been a member longer. I mean, I've been seeing you forever, Radar. So thank you for being a member of the fam. QB, I remember when you joined, QB. Thank you. Thank you. Thank you so much. Appreciate you coming on after a long day. I appreciate you. Thank you very much. Oh, yeah, and I agree. Gull does need to go to the Bahamas in May. Not happening. She's going to be sitting right there at the bench. Dawn Burke, always gifted 10 DD podcast memberships. Appreciate you, Dawn. Always. You're so giving and generous and wonderful. Thank you so much. Megan Z, $5. Where can we donate since the old link is dead? And I don't know. I am not aware of any new, if anybody in the chat knows, I'm sure that people seeing these messages would have, because we got people in here that know what's up with the I'm just swamped because I'm doing daily streams of trials. I'm not keeping track of what's going on with the fundraiser like I was, just because I'm streaming Daybell. So, and then I'm going to be streaming Karen Reed's case. So I can barely make words anymore, so I'm wrapping this. $5 hollow. Where can we donate? I'm sorry, I don't know, Megan Z. Casey at the bat. Wow, another. So 15 total. Family hugs, big time. Thank you so much, Casey. You're an amazing human. Welcome to the crew. Thank you, thank you, thank you. Bob, can judge face consequences for these decisions? What decisions? No, not really. I mean, when you say consequences, I mean the worst consequence that a judge, aside from the near impossible of them getting sanctioned by, the oversight committee for them is their shit getting overturned on appeal. That would be bad. That's a bad consequence. If Rick Allen is guilty and this thing gets overturned on appeal and he gets another trial and it's because of what Gull has done or not done and he gets acquitted, imagine if he's guilty. I don't know. I mean, that's why as a judge, I'm telling you, man, if you guys aren't watching the Chad Daybell trial, that judge on that case, spot on. Judge Boyce is a really, really good judge, like a really good judge. I really respect the hell out of him. He's handled that trial like a champion, like a judge should handle a trial. It's gotten like I don't know that he's gotten one ruling on an objection wrong. Like everything he's done has been like spot on. Holly Berry, thank you. Thank you so much, Holly. Appreciate you, girl. The best. Thank you. Thank you. Thank you. And welcome. I saw that you became a member. We adore you. You're definitely longtime fam, Holly Berry. Thank you for being here. Thank you for supporting us. We really appreciate it. Brianna Burney, Bob, can the judge face consequences? I already answered that. Sorry. Not really, aside from the thing getting overturned on appeal. Question, can the judge face consequences? Dying for the answer. Not really. Still no. So no, she really can't. Like, I mean, judges, if they make bad rulings, if they affect if their rulings can really, like, at the end of the day, affected Richard Allen's ability to get a fair trial, then the thing gets kicked back. Bob, question, how would this end up in a mistrial versus Allen getting completely off? Well, I mean, a mistrial typically has to be something that happens during the course of the trial, or a hung jury, obviously. Like if the jury cannot decide, it can end in a mistrial. There's various things that have to be extreme in order for a judge to declare a mistrial, at least later in a trial. Like I've seen early mistrials where one side or the other has made a grievous error that's considered basically unforgivable in terms of the appellate world. But and Allen getting completely off, I mean, he's got to get acquitted, but if he gets acquitted, that's what I've been saying. Like the temperature in the room is that, like, even if he gets acquitted, and it's by way of that the state didn't meet their burden, nobody that thinks that Richard Allen is currently the right guy, none of their minds are going to be changed. They are all firmly going to believe that a killer has escaped justice and is now back on the streets. That's what I'm saying. Like the only way to like truly exonerate Rick Allen and is to really kind of prove that he's factually innocent. Like to put forth evidence that somebody, like the people are like, okay, now we see it. Like getting an NG. I mean, he'll not be moving back to Delphi if he gets an NG on this thing. I guarantee you that. Like, it's rough. It's rough. I hope I answered your question, Hal. Don Burke, $20 holla. Always give her the sad part is that we may never have justice for either side. That is gospel. That's absolutely gospel. Thank you, Don, as always. Casey at the bat. Wow, you've been super, super amazingly generous tonight, Casey. Family hugs all around. Aw. I'm not feeling optimistic for the upcoming trial. Like I'm trying not to be like I said, like a Debbie Downer, the sky is falling. But like I'm just like reading this. Like I said, I didn't read this thing before coming in, and it's just, I don't know. Thank you so much for that, Casey, by the way. Nature Love 82, another always giver. No, just thank you for everything and for you to amazing to existence. For everything and for you to amazing existence. Thank you so much, Nature. I appreciate your generosity. Thank you, thank you, thank you. Dr. Vonda, fam, love you. Thank you. Like Dr. Vonda was long time in today too. She was knee deep in some Daybell with me. So thank you for hanging with me, doctor. And thank you for your incredible generosity. I always appreciate you. I appreciate you in the chat. And I appreciate you when you send me messages and information. You're just a valuable part of this community. So thank you for being here. And again, thank you for your generosity. Member for 1 month, no reporting from Lafayette. All right, good. I hope so. I hope this goes under the radar. I hope that like it doesn't get reported at all, but we shall see. We shall see. Desiree D, $10 holla. Bob, thanks so much for your coverage. I have all the same worries. Nick is playing baby games and trust his antics will catch up with him. Well, we'll see. I mean, like, we say that, but like, what happens if Alan's the right guy? Like, I don't know. Like, I think that the PCA leans innocent. I have not seen enough evidence to even come close to thinking that he's the right guy. Provided, or there's a proviso with that. It's got to go to trial. They could have more evidence. I don't like the whole thing is just scary. You know what I'm saying? Like, in like, I don't know. I don't know. Like, I just want this trial to be fair and competent. Like, we all need that to happen. You know what I'm saying? Thank you for your support. I hear what you're saying completely, obviously. Member for 3 months. Thank you for Bob. You're the bestest. No, Jen P, you're the bestest. I appreciate you. Bob and Ellie, you're so humble. I can never thank you enough for your generosity and your patience. No, thank you, Dr. Vonda. Thank you for being a member for 2 months. Thank you for being a part of the community. Holly Berry, love you. Thank you so much for becoming a member. I've been waiting. I couldn't remember. I've been loving on you forever since the early days of Publicly Buzz and my boys over there. And so I'm glad you're over here. If you've been over here for a minute, I'm sorry that I missed you. If you're brand new and finally decided to come over, thank you so much. Thank you for your support. And thank you for doing this. Thank you for gifting 5DD memberships to lucky people. Thank you. You're wonderful. Another amazing person in this community. Amanda the 5, always giver. Appreciate you, Amanda. Always. You're always coming through. Appreciate you so much. Desiree, $20 holla. I'm retyping as fast as I can. Did I hear a Core TV segment today where Vinny said trial was continued until the fall? You and MS on panel, but no faces. I couldn't hear fully, and now it's on private. That had to have been back when Scrumman and Labredo were on, and it got kicked until October. There's definitely it has not been continued. Like, we would have seen a motion for continuance here and now. So thank you for that $20 holler. Oh, Trace Evidence Pod, one of my favorite podcasts and 2 of my favorite people. I never know which one of you it is. I'm super excited to see you guys at CrimeCon and not in the not too distant future. Thank you for that $10 hour. Hey, Bob, what consequences could judges face? Just kidding. Love you, bro. Keep up, fight truth, man. I can't wait to see you guys. Just a stone throws away, really. Stone throw away. So love you guys. We'll see you soon. Thank you for the $10 holla. I appreciate it, man. What happening? $5 holla. Not this case specific, but as a lawyer, how do you guesstimate how long a trial will last? I mean, both sides kind of look at their witness lists. They kind of try to guesstimate the best they can on how long certain witnesses will take. If you've got a cop that did a majority of the investigation, that is probably a witness that could be on the stand for a few days. I mean, you do the best you can to try to figure it out. I mean, again, here, like, Gull gave these guys three weeks to finish this trial. I don't know what her position is going to be. Like, I don't know if they're getting to be like close to the 3rd week. If she's like, well, better wrap this up. I'm not like, if this is going in and beyond the date that I gave you. I mean, she could. She's talking about running this thing 6 days a week on Saturdays. So, I mean, you do the best that you can. If you've got both sides playing nice with each other, it can be a little easier. If you've got sides that are not playing nice with each other, like here, the defense will say, well, we guesstimate that our case in chief would take a couple of weeks. And the state will say, well, ours is going to take a couple of weeks, which puts us at 4 weeks, which means we're screwed here because she's only given 3. So I don't know. Thanks for that $5 holla. What happening? Rachel, $10 holla super sticker. Appreciate you always give her. Oh, my girl T. Get some rest, Bob. Love you. I love you back. Big time, T. I do. And I know you were on before me, so I appreciate that. I am indeed going to get some rest, and I thank all of you for being here. Sorry if my voice is a little strained today. It's been a long day. It really, really has. But I wasn't going to let I wanted today to be dealt with. I wanted these to get read. It would have been nice to have Allie with me. But like I just couldn't bother her. Thank you guys all so much for being here. Thank you for hanging with me for now 2 hours and 11 minutes. Thank you for continuing to support the show. Thank you for liking, subscribing, sharing, and doing all that. Thank you for becoming members. Thank you for all of it, because without you, you guys know, without question, I would just be some old man talking about old and new cases. Talk at you next time.